Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this legal education content, and today may be the day I earn your subscription. For today's live stream, we are doing our ongoing coverage of the lawsuit against the Critical K and how that is going. So when we last left the action, we gave the Critical K a 10% chance of winning. It was not going great. Her motion to dismiss was, it had something that was not total fire. So we gave some credit for that. And we also had to estimate the probability that the judges in the case will show them mercy because pro se. So because it's pro se, the judges will tend to give you a lot of latitude. Not infinite latitude, but, So we had to figure the probability that would occur and would make a difference. And so we said, about 10% seems about right. So we will read today's filings, which is the response by Ray in the motion to dismiss. And we will see if that changes our estimates. Or not, if not, at least we'll learn something along the way. Also, when we last left the action, the Critical Case still had a YouTube channel. So there was that. She doesn't have a YouTube channel anymore. So, yeah. But before her YouTube channel disappeared into the forbidden forest, she did have a post on her community tab about me. And I'm going to paraphrase because I can't read it directly because, as I said, her channel no longer exists. But the question was the comment was something along the lines of, Ray has already lost a couple defamation lawsuits in other district courts. Does that change your opinion of the probabilities of this case going differently? And so I looked at those cases, and sure enough, Ray has been found to be example for a public person and found that, she can't get the defamation from other cases. So does that change my analysis? The answer is no, it doesn't. And it doesn't change my analysis for a very critical reason. It doesn't change my analysis because it would be nice if we knew about any of that. And you say, but Uncivil, you just said the Critical K said it on their community tab. You just said that she said about these other cases. I'm like, yeah, that's true. But, the community tab isn't where that needs to be brought up. I'm not the one that needs to be informed. The relevant entity in this equation would be the district court, who doesn't know about any of these cases because it hasn't been brought to their attention. There's been no analysis done about how these cases compare and contrast with the present case, and so forth and so on. So do these cases that say that Ray can't win, do they influence the odds here? No, not really, because it would sure be nice if the district court knew about any of that, but they don't. So there's that. So yeah. Okay. So let's read her filings that we've got today, and we will see how we got. All right. Oh, Lord. So this is the motion to Rule 12 motion to dismiss. Now comes Ray, by and through counsel, and files this opposition to the dismissal. Move that over here. Ray filed her complaint on June the 4th. The summons directed Yaks to serve on the plaintiff an answer or a motion under Rule 12 within 21 days. On June the 24th, which is 20 days, so within the deadline, she filed an answer. Although Ms. Yaks therein asserts that she lacks personal jurisdiction, she raises no other 12B defense. And she doesn't really so much raise it as mention it. But then again, we're construing things liberally because it's a pro se. And then the question is, how liberally are we construing them? And that's going to be an issue for the individual judge. So we don't, it's going to become very personal, or personal is the wrong word. It's going to become very individualized based on who's reviewing your case at what in any given time. The problem here is, by the way, that the court has to do your work for you. That's why it makes such a huge difference. Personality, okay, let's just start with basic principles. Judges are, in fact, human beings. I know. I was shocked when I learned that too. Because some people seem to be under the impression that all judges should come out the same, and if they don't, that they're either ignorant or corrupt or malicious or something else. And I'm like, I have an easier explanation. Judges are people, and they're human beings, and they think about things differently, and they evaluate things differently, even where the law's the same. They approach it from different angles. They think about it differently. They weigh different things and competing priorities differently. And sometimes they come out in a different answer. Oh, that judge is corrupt. Oh, that judge is ignorant. Maybe they're just people. And, they can only go so far. The black robe thing only goes so far. It has yet to strip us of our humanity, I'm sorry to say. Wow. Yeah. So that's for a normal case where you are doing that. And then that's even more so true here, because in a normal case, like the attorneys have done all the work for you. And so you just have to like read it and evaluate it, right? And see which argument makes stronger and go into the precedent in the case law, right? It's a very sort of routine, for lack of a better word, exercise. But this is, how much does the court feel like doing your homework for you? How many chances do they want to give you? Just how liberally do they want to construe it? Just how generous are they being that day? So, yeah, it's a little hard to predict beyond that. All right, let's go to some relevant facts. Attached is a declaration. Miss Kingland explains how she viewed and transcribed various videos from her show, Critical K. Also attached are select transcripts in the body of the declaration and full transcript of one show, which is attached as an exhibit. For reasons that really pass understanding, this person seems to have completely transcribed the show, including apparently all the like chat comments. So, okay. Attached are declarations of these various people. Plaintiff rises in opposition to the motion to dismiss for lack of personal jurisdiction for reasons articulated in the attached memorandum of law, including that the defendant intentionally committed a tort in the state, which, if true, that would get you there. She has purposely availed herself of the laws of the state, and she has failed to file a memorandum brief in support of her motion. Well, that's definitely true, which then again goes to how generous does the court want to be today. All right, so let's read we don't want the declaration next. We want... Where's my thing? No. Hold on. 10.1. No, I don't want the declaration. I want the motion. Oh, memorandum is 11. Okay. There we go. All right, so here was the memorandum in support. What federal district is this filed in? Well, it's filed in the Southern District of Mississippi. So, yeah, that's what district it's in, Southern District of Mississippi. Comes now the plaintiff buying through counsel in response to this motion to dismiss. The complaint focuses on statements defendant made on her YouTube webcast when discussing the death of the plaintiff's son, Christian, who was shot in February of 2014. These statements occurred on or about March the 21st and April the 11th of 2021. In these statements, defendant claims plaintiff committed bribery and other crimes. The defendant also implicates the plaintiff in the death of another person, Hayes Mitchell, who is also a patient of Ray's, as I understand it. The declaration of Linda Kingsland, which is attached, depicts these statements, which were repeated below. So they filed a full declaration with all the stuff that went on for like 300 pages for some reason. And then, of course, they take the most important stuff and they dump it into the motion proper. So in case you're wondering. So here are some statements that that Critical K allegedly made. On March the 21st, first thing I want to say is, if Ray wants to try this case on social media, as she's been attempting to do since 2017, I'm happy to oblige her, right? I'm happy to oblige her, and until now, she's really dominated the narrative about this case via intimidation, bullying, outright lies, and I sort of set the groundwork for a lot of that the other night, and I'm going to continue to lay that groundwork and continue to provide proof of the things that I claim. Also, would have been nice if that had appeared in the response at any point. That she has attempted to control the narrative via intimidation, bullying, lies, bribery, getting people drunk, getting young people drunk, etc., etc., and that's very troubling to me. But she's really dominated the narrative, her and her family, her brother and her children, and it's time for the other side to have a say. I have the same question I did in the complaint. What exactly is the other side in this equation? So if you want to say that Ray et al. And her family are on one side, what exactly is the other side? It's time for the other side to have a say for someone who takes up the mantle for them. So Critical K over here has apparently appointed herself spokesman for the other side. How exciting. On April the 11th, defendant said, wasn't Hayes also treated by Ray? Matt Miller, I don't know that. I don't. Defendant, Dylan, was Hayes treated by Ray? Dylan, we know you were. Dylan, I was told through someone else that sometime that may have happened. I'm not 100% sure, so I can't vouch for it. But I'm sure there's someone in my group that, if it's true, can vouch for it. Matt, yeah. Defendant, it seems to me. Dylan, I. Defendant, that's something I've heard. Defendant, it seems to me that's something that I've heard, that Hayes Mitchell was also treated by Ray. I thought that was true. Did I make a mistake somewhere? I thought that was established, but maybe I made a boo-boo. Okay. Maybe I made a mistake somewhere. All right. And that's what I need people to understand. There's a whole host of young people here, specifically teenagers and young adults, who've been treated by Ray in this community via her workplace. They've been treated both counseling-wise and medically by Ray. And some of these people have been treated by her counseling-wise and medically, have gone on to be accused by her of being involved in this. This is how far her reach goes. Defendant, I really do believe that Hayes was treated by Ray, and Hayes is now dead with a drug overdose, and he was treated by Ray. He's dead also by self-harm. So she has a son that's dead by self-harm, and she has a patient that's dead by self-harm. Yeah. So that's a lot of possible facts. So Smooth Jazz says, what is the too long didn't watch about the Critical K? Well, the Critical K, the too long didn't watch, we kind of just covered, really. It's these statements that she made, which are alleging particular facts. That Ray, whatever her last name is, because I can never get it right, and a Yeho or whatever. Ray A. The allegation is Critical K said that Ray A has bribed people, gotten young people drunk, intimidated, bullied, harassed, and so forth and so on. These statements of fact that are alleged to be false. So that is what Critical K has said. And then Ray says no, and then Critical K has gone in court and the so it's been fun. Yeah. Further, as declaration Ms. Kingland shows, the defendant expounded upon her claims elsewhere in March 21st webcast. Although the complaint does not specify this additional statement, the plaintiff intends to file a motion to leave to amend the complaint to include it. Meanwhile, this additional statement from March 21st, 2021 is as follows. So, yeah, these statements were in the original complaint. They're being flushed out a little bit more, but they were there to give the court the leverage, yeah. March 21st, defendant. Well, yeah, I mean, it goes to the point, the overarching point that I've been trying to make about crossing boundaries, doing very unethical things. And I'm going to be pointing out tonight in the show another person who was bribed by Ray. See, that would be the kind of thing that we call a statement of fact. There is a person who has been bribed by Ray. That is not opinion. That's a statement of fact. To make false statements. And then I have another girl I'm talking to, Micaiah, who was, they tried to get a guy named Hunter to get her drunk, to get her talking. Again, that's a statement of fact. That Ray used Hunter to get Micaiah drunk. That would be a statement of fact. $4.99 from Get Fricked. Can you speak on CK and her channel being deleted for bullying? I'm late, so I may have missed it. Love what you do. So needed a sea of masquerading. Okay. So needed a sea of masquerading. Yeah. So I can talk about this a little bit. I don't really have any information beyond what YouTube says, which I put in the description, which was that it was, what did YouTube say? They said the channel was deleted for multiple or severe violations of YouTube's policy prohibiting content designed to harass, bully, or threaten. I have never watched anything on her channel, so I can't speak intelligently about whether she has or has not done any of those things. Apparently, YouTube reached the conclusion that they had. It does, as always, make me slightly concerned as a creator, because I'm wondering if, someday I'll be on the wrong end of something and my channel will also be canceled. So whether or not, Karen Yaks in some sense deserved it, nevertheless poses a concern to me, because YouTube standards are not exactly what I would call reasonably objective. They're so subjective that anything can mean anything. And so I worry a little bit about where it stops. So I do have a bit of a personal pragmatic concern wrapped up in it. So that's really all intelligent I can say. I don't know anything more than what YouTube has said. So that's all I can really say about that. Defendant. Yeah, she is. I've been talking to her, and the bottom line is none of that would be admissible. So statements got when a young girl has been gotten drunk, or statements that have been purchased, statements that have been bribed, none of that are admissible. That's I love how Critical K over here is ruling on admissibility of evidence. I find this cute. The Critical K has now informed all of us that these statements are not admissible at trial. Okay. Defendant, and I don't know about you, but I look at people's patterns, and I see that Ray and Todd have a pattern of bribing people with drugs and money. That, again, would be a statement of fact. That's pretty factual. Ray and Todd have bribed people with drugs and money. A pattern of which suggests more than once. That would be a statement of fact. Dylan, they're money people. Defendant, and money. They have a pattern of trying to solicit statements out of people via very nefarious means. Getting someone drunk, are you kidding me? And the problem for them is all of this is very well documented. There is proof of all of it. So there's no way to deny it, right? See, again, if there is proof of all this, that would be extremely helpful. Extremely helpful in a motion to dismiss. Karen, if there is actually proof of this, that'd be really, really great. First of all, truth is an absolute defense to defamation. This is not necessarily true in other countries in the world, but it's true in the United States. You cannot defame someone with the truth. If it's true, it's not defamation. It might be something else, but it's not defamation if it's true. So if it's true, game over, man. Game over. All you have to do is say it's true. Here it is. End of case. Game over, right? Or you go with option number 2, where you say, okay, well, even if it's not true, it comes from a reliable source, one would hope. It comes from a reliable source, and so I relied on that in addition to other things, and so I wasn't negligent / wasn't reckless, as the case may be, to rely on that. And then again, also kind of game over. So yeah, if you had these receipts, would have been nice to bring that up in the motion to dismiss. Just, what Karen actually did, not so much with the providing receipts. What she actually said is, many times, she said, it's in the public domain. Now, I've looked. And I've consulted librarians. And none of us know where to go look for the public domain. We can't find it in a shelf. We can't find it in the card catalog. We can't find it in a special room somewhere. We are all mystified about where this magical, the public domain, might be found, so we can consult it. Would have been helpful if you had actually provided the underlying things instead of just saying, it's out there to be found. Please do my homework for me. The memorandum of law includes other quotes that are also referenced in Kingsland Declaration, which she presents in the context as the argument unfolds. The plaintiff and her husband have also submitted declarations denying it. Their declarations are attached. Fair. Okay, standard of review. Break out of Susie and rhythm? Yeah. We can't... Where's the public domain? We can't find it on a train. We can't find it on a plane. We can't find it in a boat. We don't see it in that moat. We can't find it in a castle. Where it is, it truly baffles. We can't find the public domain lest we look. Let's look more. Kind of lost it there at the end with the Susian, but, you know. Did you like where I run castle with baffles? Did you like that one? Standard review, where a non-resident defendant presents a motion to dismiss for lack of personal jurisdiction, it's the plaintiff's burden to establish that in personam jurisdiction exists. The court may determine jurisdictional issue by receiving affidavits, interrogatories, depositions, oral testimony, or any combination of recognized methods of discovery. If the motion is decided without an evidentiary hearing, the plaintiff only needs to make a prima facie showing that jurisdiction exists and not required to establish jurisdiction by preponderance of the evidence. Yeah, so without an evidentiary hearing, which I'm doubting very much, we only need to make a prima facie showing, not preponderance. Fine. So, yeah. In such a case, the court must resolve all undisputed facts submitted by the plaintiff, as well as all facts contested in the affidavit in favor of jurisdiction. Well, I wouldn't say, well, maybe that's a direct quote, but if it is a direct quote, I would quibble with the court who wrote it. But yeah, all things in favor of the plaintiff is the better way to phrase it, rather than all things in favor of jurisdiction. I don't think that's quite the right phraseology, no matter what the court wrote. But all things in favor, in all facts in favor of the plaintiff, yeah, because that's what we do on a motion to dismiss, as we've explained many times, right? In a motion to dismiss, we assume everything the plaintiff says is true. We've discussed this many times. A non-resident defendant shall be subject to personal jurisdiction in a federal diversity suit, and diversity, by the way, just means... I'm sorry, I had to laugh at myself because I'm like, well, what diversity means? What it doesn't mean is like different races or different creeds or anything. It means different states. It means that it means all the plaintiffs are from different states than all the defendants. That's what diversity means. The federal court seeing diversity may assert jurisdiction if the state's long-arm statute applies, which is the name for the jurisdictional statute, as interpreted by state courts, if due process is satisfied, and if due process is satisfied. Because they've been satisfied, they can be the same. And as I understand it, Mississippi's long-arm statute is the same as the federal one because that's pretty typical. The defendant may be sued pursuant to a long-arm statute. Mississippi's long-arm statute says, so this is the one for jurisdiction for non-residents. Any non-resident person who shall commit a tort in whole or in part in the state against a resident or non-resident of the state shall by such acts or acts be deemed to be doing business in Mississippi, and there shall be subject to jurisdiction of the courts of the state. So yeah, this is where we're past sufficient minimum contacts, right? That was what we dealt with in Toddy. And maybe we'll deal with here too, for all we know, with sufficient minimum contacts. But they're going to make a slightly different argument. They're going to say we have a tort actually committed in Mississippi, in whole or part. Now, if they can prove that, then they should be home free. If they can prove that, they should be home free. And that would do it. You only need one. That, whatever you might want to say about KJ and without a crystal ball, she didn't do that. She didn't commit any tort within Washington. Right? So she didn't have that problem. So +1 for KJ and critical ball. So let's see if Karen Yax was also as smart to avoid committing any tort within Arkansas. Under the statute, any person who's committed in whole or part a tort, which is just the name for a civil wrong, by the way, that isn't from contract. A tort in this state is subject to jurisdiction in Mississippi courts. As the declarations are attached, the defendant has committed tort of defamation, at least in part, against the plaintiff in Mississippi, even though the defendant was physically in Michigan. Okay, how did they do that? On our YouTube program, the defendant has made videos about the death of the plaintiff's son, late Christian and whatever. Miss Linda Kingsland declares on a penalty of perjury she's recorded various YouTube webcasts of Critical K. Embodied in the declaration is a link to a cloud website where one may access the videos. To further aid the court, a transcript of the relevant portions of each of the programs is also attached. Thus, from the declaration, one may conclude the videos accessible by the link below are accurate recordings. We'll take it for granted for the moment. Defendant has directed her definition to a specific Mississippi resident. That's not going to fly. That's the same thing in without a crystal ball. Okay, now, what we should say actually is it shouldn't fly because that was the same thing in Toddy, right? She's making videos about Toddy's, in that case, a Washington resident. She's making videos about Ray, a Mississippi resident. It's not enough. It's not enough. So this argument doesn't work. It would be nice, however, if someone was on the other side making competent arguments to point out that this argument doesn't work. But we have yet to see any of that, but maybe someday. As the transcript of the video entitled CK Exclusive, Friend Dylan Walks with K shows, the defendant and Miss Swearington had the following exchange at 1 hour, 3 minutes, and 33 seconds into the video. Defendant, well, yeah, I mean, it goes to the point, that overarching point I've been trying to make about crossing boundaries, doing very unethical things, and I'm going to be pointing out tonight in the show. Another person who was bribed by Ray to make false statements. And then I have another girl I'm talking to, Micaiah, who was, they tried to get a guy named Hunter to drink to get her talking. Defendant, yeah, she is. I've been talking to her, and the bottom line is none of this would be admissible. Thank you for, informing us of this relative reality, apparently. Would you like to cite any competent authority? So statements got to a young girl have been drunk, or statements have been purchased. Statements that have been bribed, none of that is admissible. Defendant, by the way, it's almost certainly admissible. It just goes to credibility. Right? Because... yeah, if they're purchased or something, it goes to credibility. Also, you can note, yeah, you purchased statements. So you would probably want to admit them if you're the other side. So if person A buys statements to make against person B, if person A wants to admit those statements, okay. But person B probably also wants those statements to be admitted, because then the bribery, right? And so it speaks badly about the witness and speaks badly about the person making it. So person B probably wants it admitted, to be quite honest. So, yeah. I don't know about you, but I look at people's patterns. I see Ray and Todd have a pattern of bribing people with drugs and money. They have a pattern. And money, they have a pattern of trying to solicit statements out of people via very nefarious means. Getting someone drunk, are you kidding me? Moreover, as the video would indicate, Miss Swearington was being interviewed remotely. That is because he is a Mississippi resident. Well, that's a little bit different now. Is he talking to Miss Swearington? Yes. So the defendant and Mr. Swearington are having this exchange. So he's making these statements to Mr. Swearington, who lives in Mississippi. Uh-oh. Danger, Will Robinson, danger. So the fact that they're making statements about that is not going to fly. But that we're making statements to a third party, specifically in Mississippi, Like we were literally talking to someone in Mississippi and we are making these defamatory statements? That probably does it. That's probably game over for Karen on the jurisdiction issue. But we'll keep reading to see if we're firmly sold on that proposition. I wouldn't say we're firmly sold yet, but it's not looking great. Also, the court can take judicial notice from the recording that's entitled CK Exclusive. Christian friend Dylan chats with K, beginning at 1 hour, 16 minutes, and 10 seconds into the video. The Mr. Swearington can find only one therapist in Meridian who will treat him, implying that he lives in the Meridian, Mississippi area. Dylan says, true, I've been diagnosed with chronic PTSD. But see, the funny thing is, here's the crazy part. When I tried to get counseling in Meridian, I had one counselor, like one therapist I could go to see. Everyone else wouldn't see me because of a conflict of interest. Uh-oh. Yeah. Karen Collins says CK had him on his channel a couple times talking about this. Yeah, I'll make the same comment. I'll make the same comment I did earlier about when Karen was trying to say, oh, how about these other court cases? How do they influence it? It's like, Karen Collins, it would be really great. It'd be really great if we knew about those things, but at least up until this moment, we don't know about them yet. It's like I just told you. I'm not the person who needs to be told. So at the moment, the fact that they had all multiple times has 0% chance of impacting things. So same comment. You have to remember that the court's world is a constructed world, right? It is all the things that are in the world are a constructed world, and there's nothing outside that world, right? All the evidence that is considered as evidence formally submitted to the court, accepted per rules of evidence, right? That's all there is. There is nothing outside the reality of that. So if, no one brings it up, it doesn't exist. Therefore, a defendant was speaking to a Mississippi resident when she accused the plaintiff of bribing people to make false statements, of bribing people with drugs and money, and of getting people drunk to solicit statements. It's looking pretty good, though. On or about April the 11th, the defendant had another conversation with Dylan Swearington. The defendant had also conducted this conversation with Matt Miller. The relevant excerpt from this conversation may be found in a clip entitled John Lorden, Danielle, Highland, Kendall, Ray, Sheila Wiskocki. What kind of title is this? At 2 hours, 46 minutes, and 35 seconds in the recording. Defendant, Dylan, wasn't Hayes treated by Ray? Dylan, we know you were. And then Dylan. It seems to me, defendant. It seems to me that's something I've heard, that Hayes Mitchell was treated by Ray. That's why I need people to understand there's a whole host of young people here specifically, teenagers and young adults who've been treated by Ray in this community via her workplace. They've been treated both counseling-wise and medically by Ray. And some of these people who have been treated by her counseling-wise and medically have gone on to be accused by her of being involved in this. That is how far the reach goes. Defendant, I really do believe Hayes was treated by Ray, and Hayes is now dead with a drug overdose, and he was treated by Ray. He's dead also by self-harm. So he has a son that's dead by self-harm, and she's a patient. Now, is Dylan? It's the same guy, same Swearington guy. Okay, so we have two different statements. We have two different statements from Swearington from two different dates where these things are being communicated specifically to a person in Mississippi. That's looking pretty good. Defendant committed torts of defamation per se. In Mississippi, the following are elements of defamation. A false and defamatory statement concerning the plaintiff, an unprivileged publication to a third party. Privileged, by the way, would be to like a doctor or something, or to a lawyer, or to your wife. That would be a privileged statement. So to a stranger, basically, is unprivileged. Fault amounting to at least negligence. either actionability of the statement irrespective of special harm or the existence of special harm caused by publication. And see, again, this is where Critical K really messed up in her motion to dismiss. She messed up either at step 1 or she messed up at step 3. Because in order for there to be defamation, it has to be false, and there has to be fault to at least negligence. So this is where the Critical K screwed up. Because she says she has proof. She says she has receipts. And if she can present evidence to nullify either of these elements of defamation, she wins. She wins. The plaintiff has to have all 4. The plaintiff has to have all 4. The defendant only has to have 1. So if she can prove 1 or 3, she wins. And so it would have been really nice had she submitted, here's the proof. Right? It's true. What I said is true. Of course she gave drugs. Of course she got people drunk. Here's the proof. We're done. Or in the alternative, step 3. Here's a whole bunch of newspaper articles that said it from reliable newspapers. Here's statements that have been made by various government officials. Here's statements made by people who are close to them. So I used all those things that I'm going to present to you, and using that, not that it was necessarily true. I don't have to prove it's true at this point. Not that it was true, but it was reasonable for me to rely on it. And in doing so, I wasn't negligent. She wins. She wins. But she didn't do either of those things because she attached no receipts of any kind. She just basically said, nuh-uh. Nuh-uh was not one of the valid options, incidentally. To prove something actionable irrespective of special harm, the statements must be words imputing the guilt or commission of some criminal offense involving moral turpitude and infamous punishment, words imputing the existence of some contagious disease, words imputing unfitness in an officer who holds an office for profit, either respect to morals or inability to discharge, words imputing want of integrity or capacity, words imputing to a female a want of chastity. Word. That's old school. That's old school, but it's also common law, So it's defamation per se if you say a woman has been sleeping around and she isn't. You don't have to prove any damages. So maybe, but not to a man, incidentally. It's specifically to a woman. So that's the common law for you. Plaintiff will now outline how defendant has committed this. Well, I'm pretty much there. A false and defamatory statement. The defendant has accused plaintiff of committing bribery and tampering. Defendant has also accused plaintiff by implication of having something to do with the death of Hayes Mitchell, an alleged patient of hers. I was under the impression he was a patient, so I guess I'm confused about something. Does anyone know for certain if Hayes Mitchell was a patient of Ray or not? Because I thought it was, and I'm getting confused. I've confused myself. In her declaration, plaintiff denies the charges. She denies bribing people, getting people drunk, or having anything to do with the death. So does her husband, therefore they're false. For want of anything offered by Critical K, yeah. For want, this is true. No, it's false. For want of anything else, the defendant directed the statements to a national audience and specifically to Dylan, a Mississippi resident. Since the defendant has not asserted any privilege in her answer, which, I guess if she wants to really go for broke, she could try reporter's privilege. I don't know how that works in Mississippi, but hey, she could try that, depending on whether the statute covers her, and the Mississippi has one. So she might be able to get to privileged. depending on Mississippi's press shield statutes. So, maybe, but she didn't argue any of that. Press shield, by the way, is not a common law issue. So if you want to argue protection by the press of sources, it's not common law. You have to find something statutory, and some places have statutes and some places don't. So regardless of what you may have learned from whatever TV shows, can a reporter keep their secrets confidential? Depends where you are, man. Depends where you are. If a party fails to raise an affirmative defense in the original answer, the defense is waived. Yeah, unless the district court's feeling very charitable. But even if she could assert a privilege, it had been waived when she publicly disseminated her comments over YouTube. Not necessarily. Again, we could get in that press shield thing, because that would be the same position as a press. Like, I learned something from a source, and I don't think it's worth really getting into the weeds of whether some press shield law applies or not, because she hasn't raised it and she's not anywhere close and she's waived the defense. So it's just a musing of my mind. In some alternative world, maybe there's something there. Yeah, he was. Yeah, that's what I thought. Yeah, and I never claimed how he died. The only thing I was claiming that he was a patient. I never was claiming anything about how he died, because I thought he was a patient. So, but thanks. Yeah. Fault of the defendant. 6 minutes and 40 seconds into the episode entitled "Dismantling Apartment 801 Part 3," the defendant set the following standard for accusing people of criminal behavior. Okay. You must take into account all available evidence in a case before making a declarative statement as regards to someone's death or guilt or innocence of bystanders. That's a little bit overbroad, but it's more or less correct. Now, the reason I quibble with it, as I wouldn't go so far as to say all, that you have to take all available evidence. I don't think you have to do that for even negligence or anything. I don't think you have to pursue every lead or all the evidence. And incidentally, her saying that's the standard doesn't make it the standard, which is good enough for her, because she's protected by the law, even if she's wrong. So she says, well, you have to consider everything. Well, fortunately for her, that's not the law, because that would be really hard. So even her saying, well, this is the standard, fortunately it's not. But, otherwise, close. However, a defendant, by their own admission, has never met or spoken with plaintiff on any occasion prior to her statements about plaintiff that are subject to this complaint. You may not necessarily need to. It would be prudent, but you may not need to, again, when we're considering defamation. So instead of getting all available evidence, defendant made a declarative statement of guilt without even asking plaintiff. At the very least, this is negligence. Yeah, I don't know that I necessarily agree, although there's an interesting legal argument here, and okay, again, this is really deep into the weeds of if this was actually being done by lawyers, which it isn't, but we'll pretend it is. Okay, so here's the thing: when you're determining negligence, you have to determine duty, a violation of that duty, causality that causes the injury, and injury. So you have to have those four things, right? You have to have a duty, breach of duty, causality to injury, the injury. All right, that's what you need for negligence. So your run-of-the-mill traffic case is I wasn't paying attention, I had to pay attention, my failure to pay attention caused the accident caused damage. Right? Run-of-the-mill negligence case kind of thing. So here's the thing. When we're trying to analyze that, are we trying to assess that like objectively or subjectively? So she said that I think I have to consider everything. Now, I would argue that's not actually her duty. But she says it is. So you could try to make a colorable claim that she's imposed upon herself a greater duty than the law would actually require by making that statement. Now, I don't think that's really true, but you could make the argument, right? So if this were a pitched battle between lawyers of the two sides, we could get into a really pitched, interesting argument about whether, when she said, I have to see everything, did she, for herself, create a duty above and beyond this typical legal standard by assumption of that duty? She assumed it, and having failed to meet that duty, then that's negligence by her own definition. And then we could have a nice lawyer fight. No, that's not how it goes. It doesn't matter what she says. Yes, she assumed the risk. No, it's the public definition. No, she said it. Well, it's just a throwaway statement. It's not really that. And then, we have wonderful, fun arguments. We're not going to have any of those fun arguments because we're not playing at that level of legal analysis. But for you guys playing at home, I just want to say there's an issue there that will never see the light of day in this case, but would be fun if we did see it, which we won't, which is very disappointing for all of us. Someone asked, am I going to cover the KJ lawsuit? Yes, as soon as it's filed in federal court. I don't think it's actually happened yet. And if it has actually happened yet, let me know. As for the standard of actual malice, the plaintiff would have to demonstrate with clear and convincing evidence the defendant realized her statement was false, or she subjectively entered a serious doubt as to the truth. Although failure to investigate itself is not sufficient to establish reckless disregard, truth, actual malice can still be inferred from a publisher's failings as an investigator when the subject is not hot news. Okay? Moreover, the Supreme Court has held that evidence of intent to avoid the truth is more sufficient to satisfy the standard. Yeah, that's willful blindness. If you purposely blind yourself to the truth, like, I didn't know. Yeah, but if you're purposely putting blinders on, the court's like, you're trying not to look for a reason. So you knew that if you knew if you looked, you might find something. So yeah, that counts. Joey says, being that Ray's dad is a judge, do you think she will win? Not necessarily. My understanding is Ray has lost other suits that are at least comparable to this. I don't think her dad being a judge is, probably gives Ray a better understanding of the law than your average person, but I don't think that's going to be dispositive, and apparently hasn't been dispositive in some places. So I don't know. The reason Ray is going to win has very little to do with her father being a judge. I'm quite sure of that at this point. Thus, circumstantial evidence confirming defendant's state of mind becomes relevant. Fair. From transcripts of the programs, the plaintiff can present circumstantial evidence to demonstrate defendant deliberately chose to avoid the truth. Okay. Convince me. At 1 hour, 21 minutes, and 9 seconds into the video, Mr. Swearington explains that the criminal file regarding Christian's death is 2,700 pages long. It's a lot of pages. He said it would be impossible for anyone to explain its contents in an hour. Yeah. The defendant agrees, stating that she spent only 2 days digging into it, and she'd not gone through the gunshot residue parts. Thus, defendant has spent only 2 days reviewing 2,700-page case file before determining plaintiff had bribed witnesses and was culpable in another patient's suicide. I don't know how reviewing the criminal file of Christian's death would inform either of those things. I could, but it's not inherently obvious. Why would the criminal file regarding Christian's death have anything to say on the subject of whether Ray did or did not bribe witnesses or was culpable in some other person's suicide? It could be there. It's just you wouldn't expect it to be there. So, I'm not sure either of those goes to that, and we will definitely not be seeing that argument in a court filing near us. To explain how defendant went from complete ignorance about the death of Christian to making scandalous charges about the plaintiff in only 48 hours, a reasonable jury may infer the defendant was influenced by other motivations. About the precise nature of these motivations, only discovery will tell. Sufficient to say defendant must have had serious doubts about the allegations. Okay, why are you saying that? Defendant bases her assertion that plaintiff had bribed witnesses on the statement of John Edwards, who claimed that she was given $500 in a jar of some really, really low-grade weed by plaintiff's husband to lie on a podcast. Okay. Well, that's something, right? So that's something. So there is a statement from Jordan Edwards who says she was given $500 in a jar of some weed to lie. Okay, that's something. Jordan states, "Hi, so my name is Jordan. I'm sure the last time you guys heard of me or from me was from my podcast when I was 16 years old. And there's just some things I want to say about it, some things I want to get off my chest and just really inform you guys and let you guys know. So one being everything I said was hearsay. Everything was hearsay. I was told at 16 years old that I would receive $10,000 to provide a story to Ray when all I had received was $500 and some jar of really, really low-grade weed from Todd. And yes, I do have witnesses." Okay. And I'm also, one thing I'm very aware of that won't leave my mind is how fake I was and how folded on someone that would never do that to me. And someone that I really love, was like, I folded, okay? And I'll carry that on my back for the rest of my life. I will, and so will she, You guys are all being motivated. You're getting caught up in the hearsay just like I did. You guys want justice for Christian, but you're not giving him any because his message hasn't even been heard. I'm sorry for Whitley. I'm sorry to everyone I deceived. Well, sounds like Jordan here is saying that they got bribed, so that's something. After playing a recording of their statement from John Edwards, defendant said that she found Jordan to be sincere in their regret. However, defendant glosses over the fact that John Edwards is now an admitted liar. Okay. Thus, it would have been unreasonable for defendant to believe that, given her recantation. Especially true since defendant admits that she never spoke with plaintiff. So, okay. So, it would help a lot for plaintiff's case if they can show, because where's this quote coming from? No, apparently it's coming from the video. So apparently this was on video. So I was going to say it would be really helpful if you can show that Critical K knew about it, but she knew about it, so not so much with that argument. Okay, so yeah, this is the problem of, were you lying then or are you lying now? So if you admit to being a liar in the past, then either you're telling the truth about that, in which case you're lying, or you were lying, in which case you're lying. So you can't, when you admit being a liar, it hurts your credibility. Now, I will note that, at least as far as the jury is concerned, a jury can believe a witness's statements in whole or part, right? It's up to the jury in the exercise of their common sense. Lord help us all, but yeah. So if you as a jury member think a witness is lying about something, you can conclude they're lying about other things, or you can conclude they're telling the truth about other things. They're lying about this, but not about that. They're lying about this and this other thing, but not these things. They're lying about everything. Right? These are various conclusions that are available to you as a member of the jury. So, would it be reasonable for them to say, I'm believing this statement because it sounds credible, because it's coming in an admission? So, like how you would flip this if you were a good attorney, how you'd flip this if you were representing the Critical K and you were a good attorney, what you would do is you would say, well, they are admitting to being lying, and they're apologizing for it, and they're making the statement in sort of the furtherance of that. So the whole statement sounded sincere. So they believed my client believed all of it, including the fact that they're lying in the past, and including that they got $500. So you'd make some kind of argument about that. I believe the entire redemption story. We're not going to see anything resembling that argument, by the way, but it would be nice. After playing a recording of the statement from John, okay, we did this thing. The saga of this is now 7 years old. Thus, it's known by no means hot news. That's true. Nevertheless, defendant got rushed to see John Edwards' statements to a national audience without attempting to vet it with Ray, who certainly would have known if they attempted to bribe a witness. It's usually good practice to get a comment, or at least ask for a comment, and then, say what they said, or say they refused to comment, one of the two. It's good practice. Therefore, by juxtaposing the above with her stated motives to represent Whitley and Dillon and not being ignored, a reasonable jury may conclude defendants deliberately avoided the truth, opting instead to base her false accusations on a word of admitted lie or nothing else. I could defeat this argument. I can make this. I can make this stuff work. I'm still having massive problems with the one earlier, with the talking to the guy in Mississippi who I'm defaming. So I can make this work. Not so sure about the one from earlier with the Mississippi one. So I still might be sunk. Moreover, defendant's implied assertion plaintiff was responsible for the death of Hayes Mitchell could not have been supported by any factual predicate. Assuming arguendo, the plaintiff did treat Hayes Mitchell, which plaintiff can neither confirm nor deny due to privacy laws. I don't know if that's actually 100% true. I don't know. Maybe it's true, but I don't know if it's true. Is the name of a patient confidential under the relevant medical? I honestly don't know. And incidentally, it's not necessarily confidential for a lawyer. Who their client is. It can be under some rare circumstances, but it's not typical. So, is the mere name of the patient privileged or protected? I don't know HIPAA that well. It might be, but okay. Yeah. Only plaintiff with whom the defendant has not communicated, and Mr. Mitchell, who's deceased, would have was known what was said between the pair. Thus, defendant must have serious doubts about the implication of her statement, since she could not have been privy to any of these conversations if they happened. Well, unless Mitchell opened his mouth or something, then yeah. Thus, a reasonable jury could find defendant acting with reckless disregard for truth. It would depend on where she's getting that information from. Where is she getting it from? The idea that Mitchell might have opened his mouth is not exactly unprecedented. When was the last time a client really kept their mouth shut? Oh, Lord have mercy. Jeez, Lord, It'd be great, but, it's a pipe dream. So that Mitchell may have said something to somebody before he died, and that got represented, and those people were reliable. I mean, maybe. Is it malice? I don't know. It depends what she's basing it on, which should be no problem, barely an inconvenience, because remember, Karen has receipts for everything. So many receipts. So somehow she has a copy of his medical records. Dun, dun, dun. Yeah, it's good. Yeah. Plaintiff believes mechanisms of discovery will bring additional light to credibility of defendant's sources, as well as their state of mind, further buttressing the claim of actual malice. In the meantime, plaintiff respectfully submits that they made a prima facie case for actual malice. I could make that work. Yeah, I can make that work. I can win that argument. I can make that work. I can win that argument. Still having problems with I talked specifically to a guy in Mississippi, and I said things specifically to him that were defaming. Specifically in Mississippi, specifically. I'm having a tough time working my way around that one. But I can work my way around I can work my way around the negligence / actual malice. I can make that work. Mm-hmm. Actionability without special harm. Defendant imputed to the plaintiff guilt or commission of some criminal offense involving moral turpitude and infamous punishment. Defendant accused plaintiff of bribing a witness. That would do it. Under Mississippi law, bribing a witness is a Class 1 felony, which is punishable by incarceration of 15 years and a $5,000 fine. Therefore, by accusing plaintiff of committing a felony involving infamous punishment, defendant fulfilled the fourth element. You're there. Defendant also imputed to plaintiff a want of integrity or capacity, whether mental or pecuniary, in the conduct of profession, business, or trade. She sure did. By implying she had something to do with the death of Hayes Mitchell, it's been established in law that Mississippi for more than a century that damages are presumed in cases of defamation per se, and need not prove actual damages. Yeah, you're there. You're there on element 4 of the defamation. You're there on element 4 of defamation law. I still think I can win on element 1 and element 3. But I can't win on the personal jurisdiction issue. So I have to fight this in Mississippi. But I think I can win on the defamation issue. Yeah. I'm not saying it wouldn't be hard. I'm saying I think it's winnable. The jurisdiction one, I'm not seeing any winnability for that right now. Thus, by operation of law, plaintiff was damaged from the very moment defendant told a Mississippi resident the plaintiff had bribed a witness. See, even if you're not there for defamation, you're there for jurisdiction. So you have to fight this in Mississippi. Which isn't to say that you can't win in Mississippi, but yeah. Therefore, by committing a tort of defamation per se while speaking to a Mississippi resident, defendant committed a tort in whole or part of Mississippi. Thus, they treated the Longer statute. Yeah, on the jurisdiction thing, I mean, I'm not aware of anything specific that would rebut this. So, if I were representing this case, if I was representing this case, I'd have to go see if I can find anything. Like for the defamation stuff, I can think of arguments off the top of my head that seem colorable. So I'm like, okay, this seems winnable. I can probably win this argument. On the jurisdiction thing, I don't have anything that comes to mind. So maybe there's something out there for me to find, but she did specifically talk to someone specifically in Mississippi and specifically defamed to specifically that person. Which, you're there. So not looking real good on the jurisdiction issue right now. Not really looking good on the jurisdiction. And because the motion to dismiss is an absolute shambles for the defamation stuff, and her answer is an absolute shambles, then that means we're probably going to discovery, which means we're probably going to have depositions, which is hilarious. And if there's a deposition, I'm calling Ray's attorney, and I'm asking if I can be there. Can I sit in on that one? That would be fun. Just call me a paralegal or something. Due process requires defendants have sufficient context with forum state. In Goudry, the Fifth Circuit describes the standard for determining this. Did the defendant have minimum contacts? Did the defendant cause of action arise out of the forum contacts? Would exercise of jurisdiction be reasonable and fair? All right, so let's see if, a single act by a defendant can be enough to confer jurisdiction if the act gives rise to claim being asserted. When the act of content with communications with forum gives rise to intentional, this alone consists of personal availment. If you have one in the jurisdiction, you're there. Defendants purposely availing themselves of the privilege of causing consequences. As the videos and transcripts that are included in or linked to the various declarations show, defendants discuss a Mississippi criminal investigation concerning the death of plaintiff's son. During at least 2 of these videos, defendant contacted at least one Mississippi resident to make inquiries about the matter. Moreover, while conversing with certain Mississippi resident, that's Dylan, on our YouTube program, defendant committed the intentional tort of defamation per se. Yeah, all right, you're there on a plausible case. I guess I could argue that it isn't defamation and try to get around jurisdiction in that way, but I don't think that works. When defendant purportedly avails himself to the benefit and protection of foreign law by engaging in activity outside the state that bears reasonably foreseeable consequences in the state, means of a lawsuit does not offend traditional notices of fair play. The defendant could have foreseen their false and defamatory statements would have reasonably foreseeable consequences in the state, particularly since she was publishing the defamatory statements to a Mississippi resident. Yeah, that's where the thing completely breaks down, right? To a Mississippi resident. If it wasn't specifically to the Mississippi resident, we're back in Toddy world, and I can win that. But the thing that continues to kill us is the to a Mississippi resident. Just keep saying it over and over. Drive that knife deep in, man. I don't know how I can win that one. Ugh. I got nothing off the top of my head. Defendant purportedly availed herself of the jurisdiction by committing a tort. Indeed, the cause of action flows from her contacts within the state of Mississippi. Yeah, you're there. The Fifth Circuit lists the factor the court must consider when determining who is fair: burden on the non-resident defendant, foreign state's interest, plaintiff's interest in securing relief, interest in interstate justice system and efficient administration, shared interest of several states in furthering fundamental social policies. Okay, so now we're going to talk about some case law. Like the plaintiffs in a prior case, the injury complained of was felt by plaintiff who's a Mississippi resident. Therefore, like the plaintiffs in Brown, forcing the plaintiff to travel out of state to prosecute her action would be unfair given the defendant has chosen to attack the plaintiff in Mississippi voluntarily. Again, the distinction with Toddy is in Mississippi voluntarily. These words continue to haunt us. The plaintiff did not ask for the defendant to defame her in the state. The plaintiff did that completely of her own volition. Therefore, to require the plaintiff to travel more than 900 miles to seek redress would unfairly undermine her interest in obtaining a convenient forum to voice her grievance. Yeah. Defendant would lead this court to believe that she is without the economic means to litigate. She claims she is not rich and has two minor children to look after. She also asserts if the case were heard in Michigan, defendant would have a much better place to access free local expert advice. Despite these cries of poverty, the defendant has a recent history of expensive travel. Oops. Even since initiation of the present action. On October the 12th, the defendant filed her motion to dismiss. Because defendant is pro se, she mailed the motion to dismiss via express mail as evidenced by the envelope. Oh my God. Oh my holy Lord. Wow. The postmark from that envelope, which is depicted below, indicates the same was mailed from Hawaii. Wow. That's a hell of a cell phone there, man. I'm too poor. I can't come. Here's the court filing she filed. And she filed it not so much from Michigan, but from Hawaii. Wow. That's good. That's great. The plaintiff respectfully submits that if defendant can afford to travel more than 4,000 miles from Michigan to Hawaii after being sued, she can travel 900 miles to Michigan to Mississippi to attend a court hearing. Particularly in this day and age when they'll mostly be over Zoom. $5 from the uprising mama. Thank you very much for that. As such, defendant would suffer no undue burden. Moving to another factor, the state of Mississippi has an interest in adjudicating the dispute since plaintiff is a resident of the state. The next factor, evaluating the judicial system's interest in obtaining the most effective resolution, requires the court to consider the interests of other potential jurisdictions. The court is to look at the location of the witnesses, where the wrong underlying lawsuit occurred, what form substantive law governs the case, and whether jurisdiction is necessary to prevent piecemeal litigation. Probably not so much on the last part. Because this defamation case is where a Mississippi resident was injured in Mississippi, the law of Mississippi applies. True. Although the above factors weigh heavily in favor of this court keeping jurisdiction, this question can be reduced to one simple fact. Defendant committed the tort in Mississippi when she spoke statements to a resident. Yeah, when you keep coming back and just banging that drum because the drum's pretty good. Just keep banging that drum. It was pretty good the first time. Doesn't sound any less sweet the 10th time. As the Fifth Circuit has noted, whether a non-resident defendant commits a tort within the state or an act outside the state that causes tortious injury within the state, the tortious conduct amounts to sufficient minimum conduct. Yep. Yeah. Express mail is great, by the way. Express mail is great. It's usually next day overnight, and if not, they'll tell you. And the nice thing about express mail is it delivers every single day of the year. So if you have to send a last-minute Christmas gift, usually USPS and FedEx won't deliver, except really. I don't know that they deliver on Christmas Day. FedEx and UPS. But you know who does deliver on Christmas Day? The post office, if you send it express mail. So yeah, if you need to send that last minute Christmas gift, express mail, we'll get it done. It delivers every day of the year. Because plaintiff would request the court deny defendants Rule 12, not only because it lacks substance, but also because they failed to comply. And so not so much, and deny it. So that's all happening. Yeah. Hawaii was probably a working trip tax write-off. Well, I mean, if you still had a channel, you could cover this case on your channel, and that would make it a tax write-off. But you don't have a channel anymore. That's very sad. Rasmel Smith gives me $19.99. Hi, Uncivil. Hi, Renell. Well, just got here. Have to start from the beginning. Well, we're happy you're here, Renell. It continues not to go particularly well for our friend Karen over here. The jurisdiction issue, I think, is sunk, and the defamation issue is winnable, but not by Karen. I'd have a decent chance at it. Not so much with Karen, though. All right, what's next? All right, let's see what we got here. So let's look some just kind of formalities here. Andy Achara files the complaint. Yax file the answer. Well, 12 submissions. Attaches declaration, motion dismissed, blah, blah, blah. Okay, great. Just kind of a cover page. All right, let's take a look at these affidavits from Ray and Hubby. Carol says, you are fab. Well, thank you. I appreciate that. I appreciate your love. It does help. It helps. I appreciate your love very much. Everything. It's really appreciated. Let's see. How many people are watching right now? 217. That's actually a pretty good attendance. Thank you for the 217 of you who are here. If you haven't already, you could hit the like button. Yeah, I need to start figuring out how much I need to write off on taxes for my business. Because I have some things I could write off. So I need a CPA. I think I need to hire a CPA. Okay, so Ray declares the following. I've never offered money to anyone to lie or change facts about Christian's death or events surrounding death. John Edwards made a false allegation against me and my husband when he stated she was paid to change her story or state Whitley shot my son. Facts surrounding George Edwards' involvement in the case are following. Jordan Edwards approached my nephew, Tyler Thompson, and told him her story of events surrounding Christian's death. Her boyfriend at the time knew Tyler, and he called Tyler to arrange a phone call between Jordan and my nephew. Jordan relayed events which included her stating that Whitley shot Christian. Jordan indicated that Whitley told her and Micaiah Castleman this. Jordan also stated that Whitley had been involved in a drug trade in Lauderdale County and been questioned by Homeland Security about involvement in sex trafficking. Just by way of pointing out the obvious, like hearsay, double hearsay. I think there might have been a triple hearsay in there somewhere. So, he said that, she said that, they said, okay, good. That's just great. Tyler called his father Christian and told him what had been told to him. That's 3 levels of hearsay. Christian Thomas heard it from Tyler, who heard it from Jordan. Chris stated Tyler needed instructions Jordan to get in contact with me. Tyler contacted me and set up a meeting with Jordan. Jordan Edwards came to our home and told us essentially the same story she had told Tyler Thompson. I never asked Jordan to change her story or add to her story. I've never met Jordan Edwards prior to her coming home that night, nor have I ever spoken to her before that night. I had no contact with Jordan Edwards prior to her conversation with my nephew, in which she relayed her knowledge of the events surrounding my son's death. So much hearsay. So much hearsay. There's no possible way I could have influenced her story in any way due to never speaking to her prior to vocalizing her recall the events surrounding death and her freely given statements that Whitley shot Christian. I also deny ever offering drugs in exchange for any individual to lie. So, this would be if you were a competent lawyer, this would be where you start filing motions to strike for hearsay. Will Karen file a motion to strike because of hearsay? If she does, will she be able to get it right? I have my doubts. It wouldn't normally bother me that much in a declaration, but it's just so much. Normally, I'm a little less sensitive to hearsay in a declaration than I would be at, say, trial, but this is a lot of hearsay. So it definitely trips my hearsay meter somewhere along the line. I think it might have been the triple level hearsay that did it for me. Dylan is a resident of Lauderdale. He has been seen by my daughter and other individuals around Meridian. He has been photographed at Meridian's escape room, and these photographs posted on Facebook during the time he was engaged in conversation on Karen Yax's channel, Critical K. So, yeah, that works. He also graduated drug court in May 2021. Is graduated the right word there? Graduated drug court? Do they have a valedictorian? Do they give speeches? The photos were posted on social media displaying his mother and grandmother being present. Amy Laurent has posted on her social media platforms that Dylan has assumed a father role in her grandson's life. Amy Laurent's daughter and grandson live in Lauderdale. Amy Laurent has made comments on social media that Dylan sleeps on her couch. He's a resident. It's fine. It's fine. Dylan's residency would often has to be verified by his parole officer. Karen Yax made comments on her YouTube channel she planned a trip to Meridian to meet with Dylan and possibly film a documentary. So that's just sort of the last kick in the teeth. That she knew he was in Meridian, Mississippi, right? It's not necessarily, strictly speaking, necessary, but the fact she actually knew it, yeah, you're there. Who or what is texting me? What's going on? My brain hurts, by the way. I think it stopped working. Yes, they do have graduation for drug court here in Mississippi. Well, Ray's lawyer is watching. Hello, Ray's lawyer. Thank you. Thank you for letting me know. I, 'cause I'm serious about coming to that deposition, by the way. Amy Lawrence's daughter and grandson live in Lawrence. Okay, we covered that. Karen Yax's coverage of my son's death and case associated with his death on her channel Critical K has caused me great stress for me and other members of my family. She has frequently made threats to intimidate me and my family. She has taunted me and my family with threats to put out misinformation that would paint me and my family in a false light. She does not appear to make any efforts to vet the information she puts out, but rather takes the word of people with questionable morals and motives themselves. Her taunting and intimidating behavior has caused me not to sleep at night and to be hypervigilant and anxious due to her bragging about what she has done to people in the past, which I confer that she does to my family as well. After losing a child, all a parent wants to do is protect their surviving children. She has caused me and Christian siblings to relive the events that are painful to me and them. All families have dynamics that are private matter and should not be available for discussion and dissection on YouTube. Miss Yax's harsh critique of my parenting skills. Well, critique, as always, is lawful. That's not defamation. If it's critique, Christian siblings' reaction to death. If it's critiquing the reaction again, and trauma his older brother suffered. If it's all critiquing is legal. Has caused an increase in stress, anxiety, which has resulted in weight loss. Upon information belief, she's bragged about having my son's autopsy photos, encouraged people to pay more to be a member of her Patreon group in order to have access to his autopsy photos. Well, that's not in great taste. I'm assuming they're public record, but, still, it's not in great taste. I have found grief is a tidal wave which recedes and swamps you again and again. That sounds a lot like depression, which I can sympathize with, at least as to that much. Miss Yax's attacks, in my opinion, were an effort to drown me and my family in an effort to shock me and profit from our pain and loss. Okay, that's all great. Dun, 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 dun. Dear graduates of drug court in Mississippi 2021, dun, 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 dun. It pleases me upon the recommendation of the faculty and staff of this honorable drug court to present you with these graduation certificates. Dun, 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 dun. And to lead you into this bold new world of graduation and entering the world is our valedictorian, who would like to speak some words. I did meth. Meth really ruined my life. It caused me all kinds of problems. Caused pain between me and my family. Health issues. I feel lucky to have been caught and may have saved my life. Meth is whack, yo. Don't do meth. Inspiring words. All right, so then Lisa has a declaration which goes on for 296 pages, which we're definitely not going to read, but we'll at least read part of it. So Linda over here, who I'm not sure how she gets involved in all this necessarily, but whatever, has downloaded 4 videos of the YouTube program, which is good. It's good that she downloaded them because they're no longer available on YouTube because the channel's deleted for the harassment and bullying and so forth. The videos in this folder are Why Do I Love Plushies? Plushies are cool, I guess. Dismantling Apartment 801 Part 3, CK exclusive with Dylan, and John Lordan's whatever, which was uploaded to YouTube. Except for the clip entitled Why Do I Love Plushies, I download these videos directly from the YouTube channel. Usually within a day or two of the release date, YouTube would sometimes provide a Google-generated transcription. I download those as well when available. The clip entitled Why Do I Love Plushies was created when I used an app to trimmer from the larger Why Do I Love Plushies. Why does she love plushies? I mean, I assume we're not going to get that answer in this document, but why does she love plushies? Now I want to know. I guess I could go to the Dropbox video and I could view the whole thing if I really wanted to know, which I don't really want to know that much, but I Googled transcription, the Critical K video. These transcripts are true and correct. My transcript, the relevant part of Why Do I Love Plushies, which begins at 3:15:54. Defendant, they catfished her and said, here you go, it's apartment 801, Critical K, part 3. And they're going after your family, they said. And she puts, yes, period. It's very controlled, yes, period. This is A and I. People need to understand this, that there are certain hallmarks that reveal how someone controlling is, someone is in text. If someone double spaces, thumb taps twice. If they double space, thumb taps twice after a period. What? If they go yes, thumb taps twice. If they go yes to rump, they're hitting their thumbs twice. It's very controlling. She puts yes and double spaces. What? Double spaces after a period is a sign of a controlling personality? It's a little old school. But double spaces is a sign of a controlling personality? What? Okay. All right. Criminal imagination. How she knows she hasn't been listening. Defendant. Exactly. And she says, not many people listen to her, period. Thumb taps twice. Double space. I just ignore you. No, you don't, Ray. You don't ignore me. You're not ignoring me. You're very well aware of me. You know I have taken up for Dylan and Whitley, and I'm a force to be reckoned with. I'm a Powerball. You've never met an MFer like me, Ray. And you know it. You sense it. You're going to try to tell people that you just started ignoring me, and you're not. I'm coming for this narrative. I'm going to fight these people. I'm going to fight for fairness and balance where they're concerned, and you're really not comfortable with that because you're going to have got really used to people kowtowing to you and bowing to you and towing your narrative for you. It's becoming really easy to do online. It needs to be like, not easy, for you. Like everyone has to do that, someone, right? That's their wall. You know what my wall is? The thing I beat my head against when the pain gets too high. I've already begun working on just completely negating and destroying everything Danielle and John has claimed. And I'm going to do this with the help of Dylan and hopefully Whitley and her family, provided she's available. But they can't continue to ignore me because they're saying things that are untrue about these people I'm representing. And they need to either retract what they're saying or provide some basis for what they're saying. They're providing none. Okay. I'm going to reread those last two sentences because I need to make sure we all got it. All right? I'm going to just reread the last two sentences. This is Karen. This is Karen Yax. She is saying this. Quote, they need to either retract what they're saying or provide some basis for what they're saying. They're providing none, on quote. Okay. My transcript of another part. Let's go ahead and get started. So, Kendall Rowe begins the second part of her volumentary by saying, quote, if you believe Christian needs justice, you will sign our petition. And the problem with this statement, the problem with this question is actually declarative. She's declaring to you, the listener, that he was somehow denied justice, which is misleading on its face, so properly leading, because she cannot possibly declare that. It's not a, quote, fact, unquote, that Christian was denied justice. If anything, the facts and evidence in this case prove otherwise. They prove that Christian self-harmed on 2/26/2014. A thorough and detailed investigation was done by proper authorities, including a deep analysis of Christian himself, and conclusion was made that he self-harmed. Christian determined the justice he sadly felt deserved in his life. And I'll show you tonight he was actually worried for his family, would try to blame someone else. And for those of you who come at me with this close, the scene was botched. This argument can exist simultaneously with an incident of self-harm. I mean, that's logically true, so we'll give Karen a point, right? We'll give Karen a point. Yeah, just because the claim that the scene is botched and the person committed self-harm are not incompatible statements. I mean, that's true. That's fair enough. A scene being handled less than perfect does not automatically mean that scene was staged to make an instant look of self-harm. You know, Karen is speaking some logical truths over here somehow, so we'll give Karen some points. Yeah, you know, just because it was mishandled, so it kind of looks staged now, doesn't mean it was staged. You know, hey, true enough, man. Bonus points for Karen. She needs them. You must take account of all the available evidence in the case before making a declarative statement as regards to someone's death or guilt or innocence of any bystanders. This case has been investigated by Meridian Police, Mississippi Bureau of Investigation, the Attorney General, multiple PIs, and multiple forensic specialists. That doesn't sound like a lot of investigation. If Ray did not hire and fire so many people that overlapped and recused themselves for being beat over the head with threats, misinterpretations, and accusations, maybe the waters wouldn't be so muddy and things would have been able to be done completely and cohesively. Thank you, EG, for the super chat. You know, that's super encouraging. I'm just waiting for that someday. You know, someday my YouTube channel will be in a declaration, and there will just be, in the middle of me stating stuff, there will be the thank you whatever for the super chat, the acknowledgments. So you too may appear in a deposition someday. How fun. Or a declaration, I should say. The video, friend chats with Kay, has multiple sections. The transcript says some stuff. It's depicted both. Dylan. True, I've been diagnosed with chronic PTSD, but see the funny part, here's the crazy part. When I tried to get counseling in Meridian, I had one counselor, like one therapist. Everyone else wouldn't see me because of conflict. Yeah, I'm pretty sold on the prospect that Dylan is a resident of Mississippi. So that jurisdiction argument, you know, that looks like, yeah, the jurisdiction argument looks like a 99% winner. You know, 99% winner. And the defamation, it goes a lot to how merciful the judge is going to be. It depends on the judge. The judge is in fact master of their court, so the judge can go a far way. And then, of course, it depends a lot on Karen. So, if the judge is gracious, and Karen is gracious in return, then that will help. If, however, the judge is gracious, and Karen potentially loses her temper or, you know, speaks over the court or speaks poorly of the court or threatens the court or any of those things, it doesn't go well. So it depends a lot on the combination of the graciousness of the judge and the graciousness of Karen. Yeah, Lake Breeze. If she calls the judge a peasant, we can pretty much wrap this thing up, because yeah. Here's a tip to Karen, if she's listening: don't call the judge a peasant, please, or do, because it will be freaking hilarious. But I wouldn't necessarily recommend it unless you want to do it for me to lol at. So, you know, you do you, I guess. My transcription of this part is depicted below. First thing I want to say, if Ray wants to try this case in social media, as I've been attempting to do since 2017, I'm happy to oblige her. Right? I'm happy to oblige her until now. She's really dominated the narrative about this case via intimidation, bullying, outright lies, and I sort of set the groundwork for a lot of that the other night. I'm going to continue to lay the groundwork and continue to provide proof of the things that I claim she's been attempting to control the narrative via intimidation, bullying, lies, bribery, getting people drunk, getting young people drunk, etc., etc. So, and it's very troubling to me, but she really is dominating the narrative. Her and her family, her brother and her children. It's time for the other side, which I have no idea what that is still, to have their say. It's time for their side to have someone who takes up the mail for them, and apparently that's going to be me. Until now, they haven't really had anybody, I think. They've had maybe one or two podcasters who have attempted to accomplish this, but were quickly run off. They were quickly terrified by Christian's family, and then were sent running into submission. That's not going to happen with me. Okay. Defendant. Well, yeah, I mean, it goes to the point, the overarching point I've been trying to make about crossing boundaries, doing unethical things. I point out tonight in the show another person who bribed by Ray to make false statements. And I have another girl I'm talking to, Micaiah, to try to get a girl named Hunter to drunk from talking. And then there's some other statements and other quotes, which we won't read because we kind of covered the major ones in the complaint, but I just wanted to show you that there's a lot more of this. And then, you know, and then they include Exhibit A of the CK exclusive with Dylan, where they go on and include every comment in the chat, I think, just to like have that for some reason, or the transcript, one of the two. So, yeah. You know, it just so happened earlier today. I was watching a video of a sovereign citizen because I apparently like pain. And this sovereign citizen was facing a ticket for $235. I don't know what it was for. I kind of missed that part. So I don't know if this was a traffic ticket or some other kind of ticket. But the ticket was for $235. The sovereign citizen decides, you know what would be a great idea? What if I go into court and I threaten to harm myself? What if I threaten to harm the judge? What if I make threats? So, not so much with the fine of $235 in the end, but rather, how about the 10 years in prison? You went from a $235 fine to 10 years in prison. And that's great work. That's just great work. Super great. Super great. So, you know, I'm just saying that people have been known to escalate, and sometimes the escalation goes poorly. So, yeah. So anyways, how are we feeling about the odds of Ray winning at this point? Well, so much is determined on the judge. And it depends a lot on how the district judge handles things. So there's enough here for the district judge to rule in a fairly summary way, not for the least of reasons that Karen over here is really shit at making legal arguments. So there's a couple things the district court could do. The district court could just rule on it from papers, which is a significantly likely outcome. The district court could try to be merciful, maybe have a chat with everyone, see if Karen shows up to it. Again, if Karen is watching here, if they schedule a conference, I would say, I give this advice as an officer of the court. You should probably show up. So that could happen. Yeah, that's probably the most two likely things that happen. Either they rule on it fairly quickly and kick it back down to the magistrate judge, or the district judge tries having a talk. And depending on how the talk goes, that could influence things really far. And then we're back down to the magistrate judge, who decides how merciful they want to be to you on your motion to dismiss, which is going really, really poorly, along with your answer. And yeah, so it depends. The judge would have to be in a really good mood that day, but it's possible. So yeah, we're somewhere between 90 and 95% for Ray to win. The reason that we're not higher is because we're trying to calculate the probability that the judge, either the district judge has a talk with them or the magistrate judge has a talk with them. In either way, maybe talks them into some sanity. So that's why we're not like elevating it really, really high, because we're trying to calculate what is the probability the judge is going to be in a really good mood and give Karen a break. And then we're trying to calculate the probability that when given that break, Karen is going to spit in the magistrate/district judge's eye. So that's what we're trying to calculate, those percentages. So maybe 95% is the better, because I don't have a great deal of confidence in Karen in not screwing this completely up if the judge decides to be merciful. So I think the judge being merciful is probably 10%. But if the judge is merciful, Karen has a pretty decent chance of spitting in the judge's eye, and that will be the end of all the mercy. So I think we have to estimate it's 95% chance for Ray to win at this point. But you never know. You never know. Karen could turn this around. She could start taking it seriously and respect the court and respect its orders, and she could take notice of the cases she gave me notice of, which would have some good stuff in there for her, right? They're also dealing with some defamation stuff. So, steal. So you could use that stuff and write up some better stuff, which I'm surprised she didn't do in the first place. But, she could turn it around. It's possible. Or it's possible over here that Ray is just going to crush her. And it's going to be the most hilarious deposition ever. So I think we'll go back. I think we'll say 95% for Ray to win. A 5% chance that the judge shows mercy and she doesn't screw it up. It seems fair. Can she roll that natural 20? Can she roll that natural 20? And get a stay from the DM? That's the question we've got going on here. Yeah. I don't think this judge has ruled on any of Ray's suits. I don't think so. I think they were in different jurisdictions. I think one was in Tennessee. I think one might have been in Arkansas or something. I don't think they were in this jurisdiction. But yeah, it doesn't really matter that much because you can still steal. So yeah. Will this be recorded? What, the deposition? Oh, I'm sure it will be. It'll be on tape. It'll be great. I don't know if I can live stream the deposition, but I will definitely comment on it. So when it occurs. So yeah, I think she's lost on the jurisdiction. I can't find a winning argument for jurisdiction. It's just too much. It's just too much. She calls someone she knows is in Mississippi, and she's making defamatory statements specifically to that person. Well, calls the wrong word. Has a YouTube stream with, but same difference. I could see Critical K being like, I didn't call him. Duh. All right, fine, Karen. You didn't call, you YouTube chatted with him, because that definitely makes a difference in this analysis. So you had a YouTube conversation with them. You knew they were in Mississippi, and you made these statements, which are definitely statements of fact. And, you didn't take your own advice and provide receipts. And, Ray denies it all. So I think you're lost on the jurisdiction issue. I think you're lost. 99% to lose on the jurisdiction issue. And the defamation issue, well, it's probably winnable. Not by you, but by somebody. So, yeah. But 95% where we're sitting right now, because that doesn't seem like it's likely to happen at this point. So that's where we're sitting on this. I'll take any questions that we have as we're wrapping this up. You imagine the judge talking to her squeaking the chicken? Oh, Lord. What's the over-under on her winding up in contempt? I don't even know how that works now with contempt. I don't even know how that works. Because, it's not like the U.S., I assume it's not like the marshals are going to go to Michigan and haul her back to Mississippi. So do the judges have like space sharing arrangements? Like, I'll find you in contempt, but you'll serve your time in the jail for Detroit or something? Do they have agreements on that? I don't even know how contempt works right now in our new WebEx reality. But what's the probability she winds up in contempt? What's the probability she winds up serving some time somewhere? How much will Ray will get if she wins? Oh, it's hard to say right now. We're nowhere near being able to say that, to be quite honest. Some of these damages are assumed, some are not. There's been no statement from the plaintiff side as to damages. It's not clear how much money Karen has, but if she's anywhere close to as poor as she say, it could bankrupt her. So, I mean, I don't know, but it's possible. Do you think the plaintiff's lawyer would be interested in any other harassing that's gone on with others? I wouldn't be particularly interested. At this point, it might be valuable. I'll get that maybe in discovery and stuff like that, where if I ever went to trial. But yeah, I wouldn't have particular interest in at this stage of it. Ray gets Karen's new boat. Apparently Karen bought a boat. Okay. She's representing Dylan and Whitley. That one I could write off. Yeah. That one I can make work. Yeah, I can, as I'm trying to in my mind conjure responses that have a probability of working. I think I can make the I was representing Dylan and Whitley statement work. I think I can make that work for Karen. Still having problems with the I called a person in the state and defamed them to their person, and I knew they were a resident of that person. So I can make everything else disappear, but I have no thought in my mind for how I can make that one disappear. I got nothing. Yeah, that one might be undefeatable. Yeah. Yeah, that one's too much. Does this type of case go to mediation? I can see the judge ordering mediation. Yeah, I can definitely see that happening. Maybe she agrees to statement retracting what she said. Yeah, possible. Yeah. Yeah, I feel like I have a chance. I feel like I have a chance if I was representing Karen to make everything else work. But I don't know I can make that one work. I don't know I can make the defamation to the person in Mississippi on my YouTube stream, and I know they're in Mississippi, and I'm saying false statements of fact directly to their face. Yeah, I think I can make everything else work, but I can't make that one work. That's too much. Yeah. That's too much. iRoll says they love our channel. I'm glad you love the channel. I try to give intelligent feedback when I can. And we give intelligent feedback even when it's not caused for by the case, right? We're giving intelligent arguments about things that will never, ever be raised in this case, but we spotted the issue. It's like we spot an issue that's never going to come up, but let's talk about it anyway because it's a legal education channel. Yeah. Carol says she doesn't deserve me. I've always taken the position, and different people think about it a different way, but I've always taken the position that everyone deserves a lawyer. I get, like, for example, some of the lawyers who represent Trump in the impeachment hearing got some real crap. And for that matter, the lawyer who represented Chauvin got some real crap. And I don't really like that. And sometimes you'll hear reporters ask a question to a lawyer if they're not appointed. They'll say, yeah, they're entitled to a lawyer, but why are they entitled to you? And strictly speaking, they're not entitled to me. But if not me, then who? If not me, then who? So I would have no problem defending a client I thought I could represent, or I thought I could do something with. I thought I could help. As long as I, was able to work with my client and my client was able to work with me. So, which might be a problem in this particular relationship. But I wouldn't have a problem representing her if I thought that she had a winnable argument. Because, if she has a winnable argument, then she should win, regardless of whether she's a good person or not. And for that matter, Chauvin should have been acquitted if he should have been acquitted, which sounds stupid to say it that way. But, if that's what called for, that's what should happen. And his lawyer should absolutely argue for that. That's his job. And, so, yeah, that's all fine. Yeah. Can she refile her motions? The plaintiff can object big time, and then it becomes an issue of how gracious does the judge want to be today. Yeah, Rittenhouse's lawyer, same issue. Rittenhouse's lawyers. That case is winnable. That case is very winnable. Yeah. So, and then of course, the other thing for an attorney, that's you have to represent your client, but of course you have to represent them within the bounds of the law, which might sound obvious, but this is where we get into, say, for example, Sidney Powell and Lynn Wood, who are totally getting disbarred someday. They just got completely smacked down by the U.S. District Court hard for being frivolous in their filings. It went on for like 100 pages. It was pretty brutal. And it forms a template for the bar associations to use, and Rudy Giuliani for that matter. You can represent your client, you can represent an unpopular cause, but you have to do it within the bounds of the law. It's been said that a lawyer's first duty is to the court rather than to the client, which is probably true. Or maybe to put slightly more properly, the first duty is to the law rather than the client. Clients come and go, the law is persistent. So, I won't break the law to represent you. Deep concepts, right? Please cover the Sidney Powell opinion? I might. It is really, really long, but it was very, very brutal. Yeah, Sidney Powell and Lynn Wood are getting disbarred for sure. It's definitely going to happen someday. All right, well, I'm going to sign off for now. I hope you've enjoyed the stream. If you've enjoyed the stream, please remember to give it a like. If you're not subscribed already, why not? Please hit the subscribe button. And did you know for 99 cents, you too can become a member of the channel? It's true. You get your name in green, and you get a cool little icon by your name that shows you're a supporter, like a Leadian over here. Be more like a Leadian. Get a little cool icon by your name. Hit the join button. Help support the channel financially, and so forth and so on. And we will continue to cover this trash fire of a case as it continues. Until later, my friends, I hope all is well. Cheers, and goodbye.